Well, hello, dear learners. I welcome you all on the SPOIM portal in this session. I have already uh, welcome all of you previously while taking the classes on SPOIM portal. Now today I am here to uh, welcome your questions on any topic relating to the Muslim law, on any subject, on any topic, even something which may not be directly relevant to the subject matter may also be discussed over here. So first of all, I would like to know the question from any learner who is on here may ask any question relating to the subject, may be directly related or may be connected to the subject. So all of you are welcome. One by one, you can ask the question so that I can reply all the questions. So uh, any question from anyone on the subject or relating to the subject? Huh? Right now there is no question. Zahid Ansari Sahab. So,
अस्सलाम वालेकुम
Walaikum Assalam.
सर अभी रिलेटेड टू टॉपिक
Uh,
तो कोई क्वेश्चंस
just
है
I
नहीं
want
सर
to take you.
related to topic I don't have any question because I'm all done to the weekend 9 and studies also is perfectly is going on but the only thing is that I missed the examination date which I missed out the email that one so is
You
there
missed
any
the examination date.
yeah so is there any possibility to like I can appear for the exam because almost I completed the section week 10 is going
Okay,
on
okay.
now.
There is. I think we will notify it again, and then
Okay,
you can join it. So far as the examination is concerned, you will be given one more
okay,
opportunity to log in and appear in the examination as per rules.
okay,
So that is not a problem. That will continue. I think
okay, sir. Thank you very much.
so. No problem. But any recent development regarding which anybody wants to listen on any topic? Because the topic that so far as the subject is concerned, it is very sensitive. Almost so many litigations are pending before the court on the various subject matter or on various topics. So, anything, because in the recent past, some ruling has been given by the Supreme Court relating to the maintenance, because earlier the rule was that if the parties were Muslim and divorce has taken place and the wife wanted to claim the maintenance, then the parties could claim the maintenance only under the provisions of Muslim Women Protection of Rights and Divorce Act 1986. Uh, However, they could also avail Section 125 of the old CRPC and claim the maintenance. Wife was allowed to claim the maintenance, provided the husband, who was the other party, gave his consent to the wife to file the suit under section 1, meaning thereby that a Muslim wife uh, was entitled to claim the maintenance only under section 3 subclass 1 of the Muslim Women Protection of Rights and Divorce Act 1986. She was not allowed to claim under section 125 except where the husband and wife both mutually agreed that instead of going under section 1 section 3 subclass 1, they want to go under section 125. Only in that very circumstance joint application was moved, and on the joint application the magistrate could allow even to claim the maintenance under section 125 subclass 1 of the old CRPC. But now recently, this rule has also been watered down, has been relaxed. And now the Supreme Court, while his ruling, has allowed that henceforth a Muslim divorcee is entitled, is having the option either to invoke section 125, now it is section 141 of the CRPC, new CRPC, 144, section 144 of the CRPC, meaning thereby that now the option is with a Muslim divorcee who is wishing to claim the maintenance from her husband, she can file the maintenance application either under section 144 of the CRPC, or that is Nyay BNSS under section 144 of the BNSS. At the same time, she has option to invoke section 3 subclass 1 of the Muslim Women Protection of Rights and Divorce Act 1986. So now it is the liberty of the wife. Wife is having the liberty either to invoke the section 144 of the BNSS or section 3 subclass 1 of the Muslim Women Protection of Rights and Divorce Act 1986. Otherwise, earlier she was entitled to claim the maintenance only under section 3 subclass 1 of the Muslim Women Protection of Rights and Divorce Act 1986. So this is the new ruling given by the Supreme Court so far as the maintenance right to maintenance is concerned, meaning thereby this scope of moving the application has been expanded and by the Supreme Court, has been relaxed by the Supreme Court, and now wife can go either, has option to invoke section 3 or section 144. So this is one of the development that has taken place relating to the maintenance right of a Muslim divorcee. So you can go through all these provisions because they will be beneficial in future in case somebody is interested to know. Second thing is that so far as the procedure of divorce is concerned, so far as the modes of the divorce are concerned, I have already discussed in my lectures that it before the passing of Muslim Women Protection of Rights on Marriage Act 2019, there were three modes of divorce, meaning thereby a husband could pronounce the divorce either by talaqul sunnat or talaqul biddat. Talaqul Sunnat was further classified into two, Talaq Ahsan and Talaq Hasan. And next was Talaqul Bidat, meaning thereby that there were three recognized mode of pronouncing the divorce by the husband. He could pronounce the divorce by by invoking the formula of Talaq Ahsan. He was also allowed to set aside the marriage union by invoking the formula of Talaq Hasan. At the same time, a Muslim husband was also allowed to set aside his marriage, to dissolve his marriage by resorting to the formula of triple divorce. So, in this way, a Muslim husband was at liberty to pronounce a divorce upon his wife uh, by way of talaq-e-ahsan, by way of talaq-e-hasan, as well as by way of talaqul biddat, that is also known as triple divorce. So far as the validity of the triple divorce is concerned, it has always been in dispute. There has been difference of the opinion among the jurists of the Islam also right from the very beginning. And triple divorce did not have the absolute approval of the Holy Quran as well as the saying of the Holy Prophet. And therefore, it has been a controversial subject matter of Muslim law. And therefore, recently, not recently, but in 2019, after the decision of the Saira Banu case, a full-fledged law has been enacted by the Indian Parliament, and that law is known as Muslim Women Protection of Rights on Marriage Act 2019. After coming into force of this small piece of legislation, now there are only two modes of pronouncing the divorce, meaning thereby that now triple divorce is no more a legal formula for pronouncing the divorce by the husband upon his Muslim wife. Now there are only two recognized form of pronouncing the divorce, that is talaq-e-ahsan and talaq-e-hasan. So far as the triple divorce status of the triple divorce is concerned, in view of Section 2 of Muslim Women Protection of Rights and Divorce, Rights on Marriage Act 2019, triple divorce is illegal as well as void. Illegal means that if any Muslim husband, after coming into force of this particular act, pronounces that triple divorce upon his wife or is intending to set aside his marriage by pronouncing that triple formula of the divorce, such pronouncement will be illegal, means it will be viewed in contravention of the provisions of this act, and therefore such divorce will not be a lawful divorce, such divorce will be illegal. It will be void because Section 2 says that triple divorce will be illegal and void. So it will not be only unlawful, but also void. Void means that it will not be enforceable in the court of law, as well as it will not have any adverse impact on the status of the marriage, meaning thereby that after coming into force of this act, that is Muslim Women Protection of Rights on Marriage Act 2019, if any Muslim husband happens to pronounce triple divorces upon his wife, intending to dissolve the marriage, such pronouncement will not be lawful. At the same time, it will also not have any adverse impact on the status of the marriage. Marriage shall remain intact. It will not have the effect of dissolving the marriage. Parties will not stand separated by means of the divorce. And therefore, in case somebody pronounces the divorces simultaneously, three divorces upon his wife, earlier it was having the effect of finally dissolving the marriage. Parties were separated from each other. All the rights and obligations arising from the contract of the marriage ceases to exist after that pronouncement of the three divorces. But now, after coming into force of this particular enactment, a small piece of the system, any Muslim husband makes the pronouncement of 3 divorces simultaneously upon his wife, intending to dissolve the marriage will not be dissolved. It will not have any adverse impact upon the status of the parties. The parties will remain as husband and wife. However, if somebody uh, pronounced pronounced the 3 divorces upon his wife, then the wife will be entitled to file a suit for the prosecution of the husband. Husband can be prosecuted for pronouncing the 3 divorces because now such divorce is illegal in view of Section 2 of Muslim Women Protection of Rights and Marriage Act 2019. And in case the proceeding starts, all the evidences are produced before the court, and court is convinced that the husband in question has given to his wife a triple divorce, and thereby he intended to pronounce the divorce, then the husband will be liable to be prosecuted, and he can be awarded the sentence up to the 3 years. This is also a new development. This is also a new legal development in the field of the divorce. The triple divorce is not only illegal but also a punishable act of the Muslim husband, and he can be punished. Maximum punishment which is prescribed for pronouncing the triple divorce by a Muslim husband, it can go up to 3 years. Means the husband can be sent to the jail for a period of the 3 years. So this is also one of the development which has taken place uh, in the field of Muslim law, particularly relating to the divorce. Uh, Friends, these are the two recent developments that I have noted and made the point clear so that you should not have any sort of. Now, friends, so far as the this part of the inheritance is concerned, that is also very important from the learner's point of view, because if you go to the court of law and conduct a survey of the nature of the litigations that are pending in the law courts. So normally you will find that litigations are either relating to the status or relating to the properties. So far as the law of inheritance, Muslim law of inheritance is concerned, that deals with the devolution of the interest of a deceased Muslim upon his legal years. Means as soon as there is a death of any Muslim who was owner of certain existing movable or immovable properties, so who will succeed to his properties which has been left behind? What will be the share of a particular claimant, and how the share of a particular claimant is decided according to the Muslim law? All these points I have already discussed in detail. Uh, Normally, the people ask the question relating to the devolution of the interest of a deceased Muslim uh, upon his legal years. Say, for example, because just 2 days before there was a question from Lucknow, and somebody was asking the question that what will be the share of the father of a deceased in his property or in the property of the deceased, if there is son also. For example, if the deceased is M, say for example, deceased is M, he has died leaving behind his father and his son as well as a married daughter. Suppose these are the 3 uh, years of the deceased, that is the father of the deceased is there, claiming some property in the something in the property of the deceased, as well as there is one son of the deceased, as well as there is one daughter of the deceased. And it was also asked that father is independent person. He is also getting the pension for his past services. So whether father will be entitled to have a share in the property of the deceased in the presence of the sons and daughters of the deceased who are comparatively poor, not having so much property resources. So this type of the question was, then I replied and they were fully satisfied. Uh, One thing must be very much clear that while deciding the rights, Islam has not taken the financial condition of the parties. Right means right, and these rights have been conferred by the Holy Quran itself, uh, by the Holy Quran itself. And therefore, whatever is laid down in the Holy Quran, basically one will be entitled to that irrespective of his financial or personal resources. Say, for example, in this case, suppose father is he's drawing the pension from the government scheme. Say, for example, he's drawing 1 lakh rupees per month as pension. So that is his independent source of income. It has no connection with the hereditary right of the father. In the given case, father is entitled to 1/6 of net total property of the deceased. Means M has died leaving behind his father, his son S, his daughter D. So now in this case, irrespective of the financial condition of the father, that he is drawing 1 lakh rupees per month as pension, still he will be entitled to get 1/6 of the net total property of the deceased M. Rest of the property, 5 by 6, because the leftover property will be 5 by 6. So 5 by 6 property will be distributed among the son and daughter of the deceased. Son S will be entitled to the double of the daughter D. So 5 by 6 which is left, that will be called as the residue, and the residue will be divided among the residuaries. Here in this case, son and daughter will be the residuary class of the years. Being the residuary class of the years, they will be entitled to share the entire residue. However, the residue will be divided among the residuaries not equally, but a male residuary will get the double of female residuary. Here in this case, son and daughter both are the residuary. They are entitled to the residue, and the residue will be divided among the son and daughter, or in the ratio of 2:1, means double will be given to the son and single share will be given to the share. 5 by 6 will be converted into 3 lots. 5 by 18, 5 by 18, 5 by 18. 10 by 18 will be allotted to the son S, and 5 by 18, that is one share, will be given to the daughter D. And in this way, the residue property of the deceased M will go to the residuary class of the years, who in the given example are the son and daughter, and the mode of the distribution of the residue will be as I have just exemplified. The double share, that is 10 by 18 will go to the son, and 5 by 18 will go to the daughter, and in this way residue will be distributed. Now in the given case, in the same case, there was further question. Had there been only daughter, no son, what could have been the share of the father? Rule is entirely different in this circumstance. In this circumstance, the father will be entitled to inherit in double capacity. He will be entitled to inherit as a class 1 year, as a Quranic year. He will take 1/6 of the net total property of the deceased, as well as residue, if any. Means after allotting share to the other years, if anything is still left, that will be the residue, and residue will also go to the father. So in this case, say for example, the deceased has left behind only father and his daughter D. In this case, father will take 1/6 as a Quranic year, as a class 1 year, and daughter here is also entitled as a class 1 as a Quranic year, and therefore the share of the daughter will also be here 1/2. Means half of the property of the deceased will go directly to the daughter D, and 1/6 property will go to the father S. 1/6 plus 1/2 has already been allotted. After allotting 1/6 and 1/2, whatever is left, that will be the residue. And again, the residue will go back to the father. And so here father will take 1/6 plus residue, whatever will be left. And in this way, the share of the father will be entirely different from the share of the father in earlier example. So these are very interesting cases. I think sometimes people ask the question, what is the share of the stepmother? Is there any scope for the share of stepmother? Ladies and gentlemen, already made the clear that step relation, foster relation, and illegitimate relation are not recognized for the purpose of inheritance under Muslim law. Therefore, stepfather, stepmother, stepson, stepdaughter, they are totally out of the purview of the scheme of inheritance. Reason is that under Muslim law, basis and cause of inheritance is blood connection of the claimant with the deceased. Only one who is having the blood connection with the deceased will be entitled to inherit the property. Out of the person connected by blood to the deceased, one who is nearest, the nearest will exclude to the remote. This is also a formula. And therefore, since the stepson is not having the blood connection with the stepfather, therefore stepson will not be entitled to claim any share out of the property of the stepfather. Likewise, stepfather will also not be entitled to claim any share in the property of the stepson, because between the stepfather and stepson, there exists no blood connection which is necessary for the rise of right of inheritance under Muslim law. Therefore, step relation are totally out of the purview of the scheme of inheritance under Muslim law. It must be very much clear. So is the case with the adopted son and daughters. If somebody is a Muslim and he has taken a child in his care, has brought up the child just like his son or daughter, he may be called formally, he may be called as stepson, adopted son or adopted daughter. Now, stepson is now a grown-up person. He is also married. He is living with the adoptive father, just like a son. And everybody is knowing that he is just like a son of the person who has taken into care of that very child. All of a sudden, the father dies, adoptive father dies, leaving behind huge property. Now, adopted son or daughter, as the case may be, after the death of the adoptive father, in his property, he or she will have no share. He will be just treated just like a stranger for the purpose of, because even in adopted case, in adoption also, there is no blood connection between adoptive parents and the adopted the adopted child. Yes.
On behalf of Professor Mohammed Wasim Ali, I am here official TA and concluding this session. If there is any query, you may raise it. Otherwise, session is almost finished. And thank you very much for your kind support. Thank you very much.